Good day, viewers. This is episode one of the Slarskey LLC series on litigation funding. In this series, we explore hot topics in the emerging area of litigation funding. Today's episode focuses on litigation funding in the mass tort space. I'm Eben Freed. I'm a partner at Slarskey LLC. We are a New York-based litigation boutique. I have had a footprint in the litigation finance space for over 15 years. And currently, among other areas of dispute resolution, we represent clients in an array of legal ethical disputes. Often those touch on matters related to litigation funding. I'm joined today with Ted Farrell of Litigation Funding Advisers. Ted.
Hey, how are you?
Little intro on yourself, Ted?
Yeah, so my name is Ted Farrell. So I'm the founder of Litigation Funding Advisers. I came into the funding world as a lawyer in private practice that used litigation funding, later took a job as a managing director at a global legal finance firm, and in 2019 launched Litigation Funding Advisers, and I advise law firms and claim holders on funding their cases, and then also do work for litigation funders, multi-strategy hedge funds, private equity funds. I do advisory work, helping them look at deals that they're either thinking of exiting or thinking of investing in.
Got it. So you have, you threw around a bunch of terms: law firms, claimants, funders, hedge funds. Where exactly in the ecosystem of litigation funding does litigation funding advisors sit?
So where I sit is, a lot of times what I'm doing is I'm playing the matchmaker. Because I had been a lawyer using funding, and then I had also worked at a litigation funder, albeit relatively briefly. I've been lucky enough to sort of, sit on both sides of the trade. So, at the law firm, I kind of know, what the law firm wants, but more importantly, what the law firm needs. And it was the same thing from the funder, right? There's certain returns that we would love to get, but then there's certain returns we need. And so a lot of times what I'm doing is I'm taking, an opportunity, it's $2 million for a single case, it's $50 million for a whole law firm loan, and really, matching up sort of, I think, the best counterparties for the situation, and then helping them, get through what are the important points of the deal, just sort of, shepherding my clients, through the process of getting the funding done. Because as you know, because most of this is private capital, it's obviously a very opaque world. And, I've found that there is a real role for someone who spends all their time in this world to walk, people through and get these deals done in the most efficient manner as possible.
Sure. I mean, these transactions aren't exactly commercial credit or a mortgage where there are form documents out there. There's a ton of nuance and specialization to the structures of these transactions.
Yeah, and the thing that, when people really ask me, well, why is it so different? They say, well, for example, if you take out a mortgage on your house, the reason there's a form document is you make a down payment, and if after a certain time you stop paying, they're going to take your house and sell it to somebody else. Or same thing with the car loan. And because what we're talking about here is, money to be used for a law firm's operations, or money to pursue a certain claim, by its nature, it is very hard to game out, an expected payment schedule. Now, that's why this is an attractive asset class, I think, because you can command higher returns because of the risk. But because of that, look, while every funder says, we offer bespoke solutions and every situation is different, situations are different. I mean, they just are. And, it's really hard for, someone, who's a busy lawyer, who's probably working 12 hours a day and then thinking about work 6 hours a day and sleeping for, the rest of the time. It's really hard for them to walk through this, what's oftentimes a new sort of capital transaction for them that involves all sorts of things with client issues and, firm ethical issues and allocation of monies. And so there really is, I think, there is a real role to, have somebody to walk you through all that stuff.
Sure. Well, let's shift bases for a minute. Let's talk about the mass tort space specifically.
Sure.
when I think of mass torts, I think of, individuals who have personal claims, and that can range from a few $1,000s to several $1,000,000 per claim. What are we really talking about when we're talking about mass tort funding, and who's receiving the money in the typical transaction that you work on?
Sure. So I think there's two broad types of transactions. The first kind of transaction is where, like if you were in a car accident and somebody thought, you'll someday settle for 50 grand, they might give you 5 or 10 grand for living expenses. I do not work on those. Those are direct to consumer products. And actually there's a fairly, depending on the state, there's some pretty sort of stringent guidelines about what those can look like. So look, there's big companies that do that. I don't work on that direct to consumer. Where I do work, and I think where a lot of people at least sort of see where some of this money goes is in, a large mass tort, like, the CPAP breathing apparatus, right, has been recalled. And there's a report by, one of the government agencies saying, I think, and saying these can cause death or serious injury. And so then you would, predictably see, television commercials, right? Or pop-up ads
Hmm.
on YouTube videos, because, if you are injured, or you're potentially injured, you have to go out and assert your claim, right? So taking a step back, if there's a class action saying, the airbag in your car was faulty and you deserve $1,000, that class action is going to be litigated. And then when it's over, there's going to be a claim period where you can come put your claim in. In a mass tort, like any other personal injury case, you must go out and, assert your claim. And so, law firms naturally, if they think that the Philips CPAP device, or whatever tort you're in, they're going to want to, like any other business, they're going to want to attract clients. And so there's a lot of money that's given, usually, these are loans to law firms, and they use it for, a lot of it's for advertising, but there's actually a lot more that it's used for that sort of goes under the radar, that we can get into.
Yeah, I was gonna say, look, when I think about mass tort, I think about late night advertisements on the television. In my day, kids these days, I think they open Instagram and they can see, the mass tort firms advertising on, Instagram, social media, YouTube, whatever the case may be. Is most of the money that you're sourcing for these law firms being used to fuel advertisement, or how else are the funders, or how else are the law firms using the money that they pull in from the litigation finance firms?
So a material amount is used for advertising, but I think what is sort of lost here. And so let's just talk about one claim, right? So let's say you called me up and said, I have this condition and I had
Hmm.
this device. So your case has hard costs. So depending what state you're filing in, it could be $400 or $500 to file your case. Well,
Hmm.
you probably don't want to front that money. And then you claim you have this injury, so someone has to order your actual medical records. And then more importantly than ordering the medical records, generally, you would have a nurse review those records. So when it comes time to settle, you go to the checklist. Did they use the device? Yes. Was the surgery this day? What was this? So, to work up an individual's case,
Hmm.
can cost thousands of dollars per case. And so, look, I'll go to a conference, right? And someone sort of new to the space will be like, wow, that law firm, I heard they have 5,000 clients in this mass tort. How do I get there? And I said, well, at $3,000 a pop,
Hmm.
just come up with 15 million bucks, and you too could, be doing those cases. So the operations, and look, a lot is spent on advertising. I mean, no one's going to deny that, but the hard costs of these cases are very real, because each individual case must work. For example, if you think about the Camp Lejeune case, which everyone
Hmm.
has heard of, right? And so in that case, basically what happened is they passed a law saying there's no sovereign immunity, and therefore, if you were at Camp Lejeune, you may actually file a claim in the district courts in North Carolina. each individual case must go through its own individual administrative process before you can even file that claim. That requires attorneys, that requires paralegals. So those cases are very capital intensive, and you cannot recover unless you can prove up these injuries.
Sure. So we're not talking just about a couple $100 filing fee or, transcript fees for a deposition here or there. We're talking about a lot of medical expenses for each individual plaintiff. And when a law firm has a docket of tens or hundreds or even thousands of these claims, we're talking about what magnitude of money?
Yeah. So, I mean, look, if you had, let's say your average case workup is $3,000, right? Give or take. Well, if you have 10,000 clients, is that 30 million bucks? Am I right? Something like that sounds about right. So it's obviously very capital intensive. And so that, I think, and look, the other thing I will say about this is, lawyers have always needed money for these cases, right? So in the old days, maybe the cases were a little smaller, and more like, look, if you and I were starting a mass tort firm today, maybe we would agree to do all the work, and some lawyers who were sort of towards the tail end of their career, who really had a lot of money, would lend us the money, right? So I think it's just grown, it's just sort of grown, which has fueled the need for institutional capital, but has attracted institutional capital into these cases.
Sure. And as these cases get more complex and presumably the law firms are getting more sophisticated, the check size goes up, that an individual law firm needs to be a relevant player in any particular mass tort case, and to get into a seat where they're at the center of it all, as opposed to being a peripheral firm. Why is all this attractive for? So we're really talking about the sell side, right? We understand why the claimants need it, or the law firms on behalf of the claimants effectively need it to get the case off the ground. Why is the huge influx of this attractive from the funder's perspective, the buy side?
Well, look, it's private credit, right? And there's always going to be a demand for private credit. And,
Hmm.
there are, there are law firms you would look at who are saying, we want to borrow, we want a $20 million non-recourse loan. And, you could underwrite the docket, and you could pretty much say to yourself, like, unless we have huge changes in how the law runs in this country, it's not going to be less than 20 million coming back. It's probably going to be
Hmm.
40, 60, 80, 100.
Sure.
And so, on the one sense, it's just because, money is raised and capital needs to be allocated to good credit risk. So that's number one. But number two is, this is about as uncorrelated an asset class as you could have. So, if the average, claim holder that had this defective device is going to get X dollars, unless the company goes into real financial peril, which I think is, sort of correlated to the market, but that would be if everything went in financial peril. It's a relatively uncorrelated.
Hmm.
It's relatively uncorrelated. And so I think that has been the attraction. But what I will say is, the money going in here is very smart. So like, I don't think people are calling saying, how do I invest $5,000 in a lawsuit? Right. So and look, you certainly know some of the large multi-strats and credit
Hmm.
funds that would be doing this. They've done a lot of homework before they get involved.
Got it. So let's before we move on, let's talk about pricing a little bit. I mean, you have at the bottom, you have secured loans, right, with personal guarantees, and real tangible collateral that might be available to a typical business. On the other side of the spectrum, you have, single shot litigation finance, one opportunity, and it's either going to go 0 or 1. Where on that spectrum do these mass tort law firm financings kind of sit?
Right. So generally, I think you sort of parse it out very well. So like, there's two kinds of pricing, right? So
Hmm.
if the most important question is if, that's going to be expensive.
Sure. What are we
If the
talking
most
about?
important question is when, it should be, right, it should be a lot cheaper. And again,
Right.
nothing's guaranteed, but look, there are cases that are mature enough that that there's going to be money. There've already been
Mhm.
settlements there. So, many of these law firms, especially if they are a good operator with a track record and, they have a broad docket such that if one case sort of gets delayed, the other ones go, those generally price in sort of, those are more credit style deals as opposed to what you see in, you know, we're going to bring, we think our competitor stole our trade secret. Well, even if it's a great case, there's a 20% chance that the whole thing is going to lose, right? So the other thing I think to remember here is in these law firm loans, even the ones that don't perform, it would be rare that the entire investment's lost, right? Whereas in
Uh,
a piece of litigation, you could put 8 or 10 million bucks in, you lose on summary judgment, and you're getting a -8 or a -10. Whereas maybe in a law firm, maybe you only get your principal back, maybe you come up a little short, but
mhm.
you're unlikely to lose all of it. You're
Sure.
less likely from an underwriting perspective to lose all of it.
Yeah, that said, I mean, it's I forgot who said that used this term at one point to me. It's still an elevator profession where it's contingent on the lawyer getting in the elevator every day, going to work, and actually working it out, and that involves an element of human risk. Number one to the case, but also that you're engaging with a counterparty that's ultimately going to pay you back at the end of the day. And I think, at least from my perspective, that's a big reason why the rates of these or the implicit rate of these transactions is greater than something that's backed by hard
That
collateral.
you could
It's not
foreclose on,
exact
right? Yeah, if you have
exactly. You
a
could,
yeah,
yeah,
if you want to open a rental car company,
right.
right? And like you don't want to pay me back, like I can buy all the cars and sell them, and I'm not going to make money doing that, but I can mitigate. No, so it's interesting because in commercial litigation finance,
Hmm.
the risks are usually with can this case win?
Sure.
And in mass torts, it's counterparty risk. But the other one, and by the way, this is obviously bled into commercial, as you know, but it's duration.
Hmm.
And duration risk is the one that keeps everybody up at night,
For sure.
Yeah.
Yeah. Well, let's shift bases for a minute. I want to talk a little bit about your practice and where you sit in the ecosphere. The counterparties that seemingly you work with the most are law firms. Your clients are law firms. You're working with them. You're consulting with them. These are lawyers. They went to law school just like you or me. Why does an entity like that need an advisor or seek out an advisor when they're looking into mass tort funding?
So a lot of times they've had a bad experience. They had a lender they didn't
Hmm.
like. And so, part of like what I would offer, there's obviously other sort of advisors in the space, but look, one of the things you buy, like when you're hiring me or another advisor, is like all of the slings and arrows that I've taken, like you're buying those, right? So for example,
Tell
but
me
it's like
more,
this, right?
Ted.
Like who shows up at the conference, like
Sure.
they're the best in the world and they have a gazillion dollars and then is never going to close. Well, nobody says on our website, we don't really have any money, we're never going to close. But, I found out the hard way, right? And so I think there's part of that. But the other thing is, and this is something that, especially for a litigator, that you sort of don't think about is, when you think about how a fund works, right? A fund has an investment period,
Hmm.
and then a fund has a harvest period, and then there's like some extensions. So you may have done a deal 2 years ago with Funder X and you loved them, but Funder X might already be out of its investment period. And yes, they might be raising fund two, but it might not be there yet. Now, again, on our website, we're not going to write, hey, don't send us anything. We don't have any money now. Because, if the greatest deal in the world comes in, you can just call an LP and try to do it
Hmm.
through a managed account. And so part of what I give people, and again, like I don't, if you call me and we're a mass tort law firm, I'm not going to say before we start, these are the 10 worst people, these are the 10 best people, these guys are out of money. But instead, it would be like, hey, I think we should go to these four because I think the time is right. And maybe the time is right because fund two just closed. And
Hmm.
so, so that's really a part of it. And then just now, having been through closings with certain people, what points do they have to have, right? Like
Hmm.
there's some things people have to have. Like I remember I did a deal once and it said something like, you know, a lot of deals will say, you know, in the event you're bankrupt, we can become your attorney in fact, or something like that.
Ah,
And that has a meaning. But this one said, no, this one said, in the event of a material risk of a bankruptcy, we can become your attorney in fact. And that seemed really weird. And so I called up and they said, we have an LP, and that situation arose once. And had they had that language, it would have saved everything. So there's
mm-hmm.
nothing I can do about it. And like, you know, so it's sort of like stuff like that, sort of the inside baseball is really kind of what I offer.